I have two questions. Would you answer the argument on the other side that the interpretation that you are offering us would have very deleterious effects on lower compensated workers?
So I don't think this would have any deleterious effects on lower compensated workers.
Your interpretation of 602.
Yeah, it would not have any negative effects on lower compensated workers, because if you're a lower compensated worker, you would still have to satisfy 604. And our principal argument, really the question presented here, is that if you're a highly compensated employee, all you have to satisfy is 602, and you don't have to go to 604. So there's no effect here, really, on lower compensated workers at all. They still have to comply with Section 604. And I think, to the contrary, the problem with the government's position here is in their own reg. In 601 subsection C, it says that high compensation is a strong indicator of exempt status. But the government seems to forget about that. But the point is, I mean, if you look at 604B, it's a somewhat puzzling provision, because it's a provision that says that we don't want you to make too much money in addition to your minimum guarantee. So if you're guaranteed by salary $24,000 a year, if you make up to $12,000 in extra, that's okay. But if you can make $24,000 in extra, that's not okay. And that's puzzling enough on its face to me, because I personally prefer to make the extra 24 instead of the extra 12. But I guess what they're concerned about there is there may be some misclassification with lower compensated workers, and so they need to police that. But the reason you don't need to police that for highly compensated workers is what the government itself tells you on the face of the reg, which is high compensation is a strong indicator of an exempt status.
Okay, second question. At the end of its brief, the government says, look, you can, you know, they say, we understand that the situation of employees who work out on these oil rigs is different, but you could just alter the pay structure. It's pretty easy to alter the pay structure to avoid the result that you want to avoid here. Are they right about that?
I mean, they are right that it is possible to change the pay structure, but I think it's revealing. I mean, one of the options they give us to change the pay structure is we have to up the minimum guarantee to something like $4,000 an hour, so that the minimum guarantee has a certain reasonable relationship to the additional compensation. But if there's one thing I thought that the regs were pretty clear about, is that all the total annual compensation had to include was $455 per week paid on a salary basis, not $4,000 paid on a salary basis. So I think their alternative way of doing this just shows that they are really deviating from what the regulation applies. And of course, nothing we can do prospectively to change things is going to avoid massive, massive windfalls